So, good afternoon from Belo Horizonte. Good morning to those joining us from New Zealand. Good evening in Italy. On behalf of the Brazilian branch of the International Law Association and the Federal University of Minas Gerais, it's my great pleasure to welcome you to this ILA Brazil Masterclass on due diligence in international law, current perspectives on the work of the International Law Commission. My name is Lucas Carlos Lima. I'm a professor of international law here at UFMG and also the director of studies of the Brazilian branch of the ILA. It's a great pleasure to me to moderate today's discussion and, above all, to welcome two distinguished international lawyers whose work has contributed substantially to our understanding of the subject before us. Few expressions are as familiar in contemporary international law as yet as difficult to define as due diligence. We encounter it in international environmental law, the law of the sea, human rights law, cybersecurity, and several other fields. International courts and tribunals invoke it. States rely on it. Treaties require states to prevent, protect, ensure, or to take all necessary measures to fulfill obligations. Yet, a fundamental question remains: what precisely does international law require from a state when it demands due diligence? How much effort is enough? Does the applicable standard vary according to the magnitude of the risk, the foreseeability of the harm, the scientific knowledge available, or the capabilities of state concerned? Is due diligence simply a standard of conduct attached to a particular primary obligation? How does all of this relate to the law of state responsibility? These questions explain why the International Law Commission decided in 2024 to place the topic on its long-term program of work, and in 2025 to include it in its active program and appoint Dr. Penelope Ridings as a special rapporteur. The first report, presented this year, shows how due diligence has traveled a considerable distance as an ocean. More recent, the climate change advisory opinions have given the concept renewed importance and have helped clarify some of the factors relevant to determining what diligent conduct requires in practice. The Commission's project is therefore both ambitious and necessary. Its objective is not merely to catalog the many appearances of due diligence, but also to determine whether propositions sufficiently general and sufficiently grounded in state practice can be formulated to guide states across different fields of international law. It's a particular honor to welcome Dr. Penelope Ridings to guide us through this work. Dr. Ridings is not only a member of the ILC, but she's also one of the New Zealand's most distinguished international lawyers. During her remarkable career, she has served as New Zealand Chief International Legal Advisor, an ambassador and High Commissioner, and as counsel and advocate before international courts and tribunals. She has also served in important adjudicatory and arbitral roles in international trade and investment law. Dr. Ridings, it's a genuine privilege to welcome you to this masterclass. We are deeply grateful that you have accepted our invitation and agreed to share with us your perspectives on that work that is still very much in progress. We are equally fortunate to have Professor Olino as our discussant. Professor Alice Olino is an assistant professor of international law at the University of Milano Bicocca in Italy and one of the leading scholars working on due diligence. She is the author of the important monograph, Due Diligence Obligations in International Law, published by Cambridge University Press in 2000, and she received the European Society of International Law Young Scholar Prize in 2019. Her research on nature, content, and operation of due diligence obligations make her exceptionally well placed to comment on the Commission's project. Alice, grazie mille. So after Dr. Ridings' presentation, Professor Olino will offer her comments, and we will then open the floor for questions and discussions. And please note that The final discussion will not be recorded. We hope this will allow for a particularly open and candid exchange among our speakers and participants. Without further delay, I would like to once again thank Dr. Ridings and Professor Alino for being with us today. Dr. Ridings, the floor is yours.
Thank you very much, Professor Lima. I must thank you for your very wonderful introduction. You have introduced the due diligence topic extremely well. It is my pleasure to be here, and I really appreciate you inviting me to give my perspectives on due diligence as the special rapporteur for the topic. I'm going to share my screen because I have a few slides, so you can see that now.
Yes.
What I want to explain a little bit first is that I have, as you probably know, produced my first report on due diligence in international law that has been submitted to the Commission for discussing, and it is the summary of the Commission's discussions and my response is now included in the 2026 ILC report, which is on the ILC website in Chapter 9. So you can have a look there about what the Commission has discussed. So today what I'm going to talk about is the principal findings of the first report, some conceptual questions that remain open, and the possible contribution of the Commission's work concerning the nature, content, and operation of due diligence. But first, I have to give a little context for the discussion today. I need to explain that my first report was very much a preliminary report. It deliberately proposed no draft provisions. That context will help provide some explanation as to what I did and did not cover in my first report. So the purpose was to map existing material on due diligence in international law. I did this both from a temporal perspective, from the late 19th century onwards, and then thematically, according to different areas of international law. I took this approach in order to make the broad topic of due diligence in international law more accessible. I sought primarily to look at state practice and opinio juris, together with international, regional, and national jurisprudence. Doctrine was considered more sparingly, but this was largely because I could not do justice to the wealth of scholarly writings and still maintain a relatively concise report. So as an overview, the report is to some extent selective in what was covered. But nevertheless, it has enabled me to identify the principal issues on which the Commission members and states' views will be useful in shaping the future direction of the topic. So the principal findings of the first report. The first finding, which is not surprising, is that due diligence obligations are found in different fields of international law, with similar but not always identical characteristics. Professor Lima has already identified some of those many different areas of international law. Due diligence plays a particularly important role in relation to transboundary environmental harm and the principle of prevention. And it has an established role in international human rights law and international humanitarian law. But that is only part of the many different international contexts in which due diligence is found. The second finding is that there are two conceptions of due diligence which are reflected in state practice and scholarly writings. The first is due diligence as a standard of conduct attached to specific primary obligations. And then secondly, due diligence as a general or autonomous obligation not to knowingly allow one's territory to be used for acts that harm the rights and interests of other states. And this is associated, as you probably know, with the Corfu Channel judgment of the International Court of Justice and also precepts of sovereignty and sovereign equality. So I've identified these two conceptions from examples of state practice and decisions of international courts and tribunals over the last century and more. But they're particularly apparent in the pleadings of states before the International Court of Justice in the advisory opinion on the obligations of states in respect of climate change. And they're also apparent from national state positions on the application of international law to cyberspace. I want to explain a little more about these two conceptions because they're central to the main question that remains open. So first, due diligence refers to the conduct that a state should exercise to comply with certain primary obligations. In essence here, as Professor Lima has said, due diligence is associated with a primary obligation and describes how a state should go about complying with its obligations. In other words, it describes the expected conduct of a state when faced with an international obligation with which it has to comply. So in this regard, due diligence is often referred to as a standard of conduct, but it is more than that. Indeed, state responsibility may arise if a state fails to exercise the requisite due diligence. Due diligence in this conception has been prevalent in international human rights decisions, particularly of the regional human rights courts and the Inter-American Court of Human Rights. The Inter-American Court has been consistent that due diligence is used to describe the standard of conduct that is necessary to comply with the duty to protect human rights and to comply with the state's obligations under international human rights law to prevent, investigate, punish, and remedy human rights violations of persons subject to its jurisdiction. A state's obligation to protect persons from human rights violations includes protection against violations which are the result of its own acts or omissions. So, for example, in the Mapurapan massacre case, the Inter-American Court held that the Colombian military was aware of the arrival of the Autodefensas Unidas de Colombia and their violent intentions, and the risk to the villagers was not just foreseeable, it was in fact planned in the presence of state officials. But state responsibility may also arise for failing to diligently investigate and respond to violations of human rights committed by private parties. And the case of Velázquez Rodriguez stands for this proposition. While a state is not responsible for the acts of private parties, it is responsible for permitting or failing to take appropriate measures or failing to exercise the due diligence required to prevent, punish, investigate, and redress the harm caused by those acts of private parties. In other words, a state is responsible for the lack of due diligence in preventing or responding to human rights violations committed by third parties. There are other examples where due diligence is associated with primary obligation and where compliance with the obligation is assessed according to whether a state has met its due diligence obligations. But in the interest of time, I won't detail these further. So that is the first conception of due diligence. The second conception of due diligence addresses due diligence as an obligation relating to the activities under a state's jurisdictional control, which cause harm to the rights and interests of other states. The prevention of transboundary environmental harm can be considered as an expression of this. The more general idea dates back at least to the Islands of Palmas case in 1928, where the arbitrator said that, and I quote, "The corollary of territorial sovereignty is the obligation to protect within the territory the rights of other states." So due diligence is sometimes used to express this obligation. It's also referred to as the no harm principle. The notion is that even though a state is sovereign within its territory, it should employ restraint in the exercise of its own sovereignty so as to not cause harm to another state. It's thus an expression of the sovereign equality of states. It was adopted by the International Court of Justice in the 1949 Corfu Channel case, where it was stated that every state's obligation is to not knowingly allow its territory to be used for acts contrary to the rights of other states. So this conception of due diligence has been applied in particular to international environmental law and issues between neighboring states. It encapsulates the idea that a state needs to cooperate with a neighboring state so as to not cause harm to that state. So, for example, where states share a river, a lake, or an aquifer, there's a need to cooperate in taking water from the river or aquifer, and for an upstream or neighboring state not to pollute downstream or other waters. So the 1994 Guarani Aquifer Agreement between Argentina, Brazil, Paraguay, and Uruguay is a good example of the parties collaborating in the protection of the second largest aquifer in the world. While the agreement emphasizes the sovereign rights over water resources, it also requires the parties that perform activities for utilizing the water resources of the Guarani Aquifer system to adopt all the necessary measures to avoid causing significant harm to the other parties or to the environment. So this requirement to adopt all necessary measures is a due diligence obligation for the prevention of harm and not only environmental harm. So this second conception of due diligence has also been used by some states in explaining their national positions with respect to the application of international law to cyberspace. And many states expressly refer to this conception of due diligence in their pleadings before the ICJ in the advisory opinion on climate change. But having said that, I note that the conception of due diligence as a general obligation is not universally accepted by states or by scholars. A third finding of the Commission's work concerns the functions of due diligence. So, of course, international law primarily governs the actions of states, and many obligations are placed on states, but it is not the actions of states or state organs that implicate those obligations. Rather, it can be the actions of private individuals or corporations. It is these private parties which may cause harm to another individual and implicate the obligations of states. In international law, the actions of private parties, as I'm sure you all know, which are not state organs, are not attributable to the state. So this raises a potential accountability gap if the harmful conduct of private parties cannot be addressed. And due diligence bridges this gap by requiring states to regulate private actors in certain circumstances. So it requires states to prevent activities within their territory or under their jurisdiction from causing harm to others, either within or outside its territory. This doesn't mean that harm cannot occur. That would be impossible. So it's not an absolute protection against harm. It's not what we call strict liability. But neither does it mean that if harm is caused, a state is automatically responsible. Rather, the particular circumstances of the case and the state's actions or inactions must be taken into account. So such circumstances include whether the state knew or ought to have known of the risk of harm and failed to do anything. They also include whether the state had the capability and means to respond and failed to do so. So due diligence may operate as a risk prevention and management technique. In other words, it may operate as a way in which states prevent and manage the risk of activities under their control, which may implicate their international obligations. So the control of the actions of third parties subject to a state's jurisdictional control is one of the functions and roles of due diligence. Due diligence serves another related but slightly different purpose. The classic no harm conception of due diligence is closely associated with the precepts of the sovereign equality of states. When you have two sovereign equals, each with full sovereignty within their jurisdiction, one sovereign should not cause harm to the rights of interests of another sovereign. And this is consistent with the need for cooperation between states, especially in the increasingly interconnected world in which we live. but it requires some constraint on the part of one or both of those sovereigns. And it also requires cooperation, including consultation in areas where the states' interests interact. In this way, due diligence can operate as a restraint on states' actions. Due diligence in either of its two conceptions can therefore function as potentially limiting the discretion of states to take whatever action they wish to take within their territory. Thus, it can be seen as a limit on the absolute sovereignty of states. It may even be considered the antithesis of what the SS Lotus case decided 100 years ago and what it is known for, that a state may take action within its jurisdiction unless it is prohibited from doing so. It is this fundamental role of due diligence as a mechanism to constrain the absolute sovereignty of states which sets it apart from other precepts in international law. The fourth finding is that due diligence is frequently associated with certain procedural requirements, and these include having the necessary legislative and administrative measures to, for example, protect against human rights violations and to investigate and prosecute violations when they occur. Compliance with these procedural requirements may be an indication that a resulting due diligence obligation has been met. The Bellum do Para Convention, the Inter-American Convention on the Prevention, Punishment, and Eradication of Violence Against Women, is one of the few conventions which specifically refers to due diligence. It requires state parties to apply due diligence to prevent, investigate, and impose penalties for violence against women. Some of the detailed provisions require legislative, administrative, and other appropriate measures to prevent, punish, and eradicate violence against women. In the field of international environmental law, procedural obligations may also be relevant, including notification, exchange of information, consultation, and where appropriate, risk assessment. Such procedural obligations are indeed included in the Guarani Aquifer Agreement. In the context of climate change, the Inter-American Court of Human Rights has articulated certain procedural obligations that are applicable to protect human rights, including the right to science and recognition of local, traditional, and indigenous knowledge, access to information, political participation, access to justice, and the right to defend human rights. So the fifth finding is that an assessment of due diligence requires an in concreto assessment of the circumstances of each case. In addition, there are certain common factors relevant to an in concreto assessment of whether due diligence has been exercised. And some of the common factors that scholars have identified include the degree of risk and severity of harm, actual or constructive knowledge, the means and capabilities of the state concerned, the value of the interest to be protected, the degree of control exercised over territory or persons, and the existence of preventive and monitoring measures. Importantly, the factors may differ according to the specific field of international law. So thus, in the case of climate change, the ICJ and ITLOS were of the view that other more explicit factors needed to be taken into account, including the availability of scientific and technological information and applicable international rules and standards. The Inter-American Court of Human Rights added to these the degree of vulnerability of the persons affected. So turning now to the conceptual questions that remain open. So first, the most significant unresolved question is whether and how the standard of conduct conception and the conception of a general or autonomous obligation along the lines of Corfu Channel relate to one another. Commission members were divided on this. There were different views expressed on whether there may be a single unitary concept, two distinct concepts operating at different levels of the international legal order, or even whether pursuit of the concept of an autonomous obligation should be addressed. So in my view, it's relevant for the Commission to explore both conceptions of due diligence while acknowledging the context and potential limitations of the Corfu Channel formulation. I also propose exploring whether the two could be accommodated within a single overarching concept. But I will be leaving this until I gain a better understanding of state practice in this area. A second unresolved question is the legal nature and source of due diligence. With respect to the place of due diligence within the sources of international law, we must ask, is due diligence a rule of customary international law, or is it better understood as a general principle of law? For example, some members of the Commission warned that recognizing too broad a general obligation risks creating a regime of responsibility without an internationally wrongful act. Others cautioned against using the general principle characterization to bypass the ordinary process for the formation of customary international law. Alternatively, is due diligence a standard attached to the primary obligation so that it is that primary obligation that is violated if due diligence is not exercised? Or can it even be characterized within the sources of law? So I consider it's premature to determine due diligence's status among the sources of law, and I've explicitly deferred this question pending further assessment of state practice, opinio juris, national legal systems, and jurisprudence. With respect to the relationship with other principles and norms, I acknowledge that it would be important to consider the relationship of due diligence with certain international legal principles. And these include, in particular, the principle of prevention, sovereignty, cooperation, and good faith. The third conceptual question that remains open is the nature of the type of primary obligation to which due diligence is attached. Due diligence is often associated with obligations of conduct. So in the human rights context, the Inter-American Court of Human Rights has said that the obligation of prevention of human rights violations is one of means or conduct, and that non-compliance is assessed by the application of a standard of due diligence. However, there is disagreement on whether due diligence applies exclusively to the category of obligations of conduct, or whether it also applies to obligations which exhibit features of result, where conduct is required to achieve a particular objective. So that may be such as an objective, the reduction of greenhouse gas emissions to meet the 1.5 degree target. So in discussing this, some Commission members do not see the distinction between obligations of conduct and obligations of result as being particularly useful. So further work is required to examine the conduct result distinction. And in doing so, I consider it's important to address this from a practical rather than from a purely theoretical perspective. The fourth open question is whether due diligence operates purely as falling within primary obligations, or whether it also implicates secondary rules of state responsibility. If it does implicate secondary rules of state responsibility, how does it relate to attribution and to the law on internationally wrongful acts? I'm seeking to address this relationship cautiously in future reports, respecting the integrity of the Commission's existing articles on state responsibility. A final open question is how the core content of due diligence should be reconciled with its varied application across different fields of international law. And we've already mentioned before all the various fields of international law, and they range from environmental law to investment law, arms control, space law, and cyberspace. The question is whether a genuinely common core of due diligence elements can be distilled from all these different fields of international law without eroding or while preserving the specific features of individual regimes. And there were also questions as to how principles such as common but differentiated responsibilities and sovereignty and sovereign equality interact with due diligence. And this needs to be looked at from a general perspective, but also potentially in different fields of international law. So turning to the possible contribution of the Commission's work, the purpose of the topic is to bring greater clarity to the nature, content, and operation of due diligence. I need to recall that the Commission is at the beginning of this journey. If this topic follows the course of other topics, it will take 5 years or so to complete. During that time, I hope that the Commission and states will reach a common understanding of due diligence. But I want to turn now to some of the areas of possible contribution of the Commission's work. So first is the nature of due diligence. Due diligence has been described as one of the most ambiguous concepts in international law. There's a lack of clarity over what is meant by due diligence, the circumstances in which due diligence obligations arises, how a state should comply with its due diligence obligation, and the legal character of a due diligence obligation. One of the contributions of the Commission's work will be in achieving greater clarity over the nature and legal character of due diligence. This can also include clarifying due diligence relationship with the principle of prevention, obligations to ensure respect for international humanitarian law, the precautionary principle or approach, the concept of margin of appreciation in international human rights law, and the principle of good faith. It also includes clarifying the relationship of due diligence with the customary international law rules on state responsibility. So, secondly, the content of due diligence. In my view, the work of the Commission can also contribute to an understanding of the relevant factors to be taken into account in complying with a due diligence obligation. I've already mentioned that there seems to be some convergence in these factors. What is important is not only the identification of these factors, but also how they relate to each other. For example, how does the proximity and gravity of a risk affect the degree of due diligence that is required, whether that degree is a stringent or enhanced due diligence or not? How do the means and capabilities of states affect the level of due diligence reasonably expected of a state? The Commission could also assist in clarifying and identifying the substantive and procedural dimensions of due diligence. There also appear to be certain formulations in treaties that are commonly associated with a due diligence obligation, especially in certain fields of international law, such as law of the sea. And this includes phrases such as to ensure the protection of the marine environment, as in the ITLOS Advisory Opinion on Climate Change. Identifying the formulations commonly associated with due diligence could provide practical guidance to states in the negotiation and drafting of treaties, and in understanding the commitments resulting from the treaties they sign. Having said that, I would also emphasize that the existence and content of due diligence depends primarily on the context, object, and purpose of the applicable primary obligations. So the third possible contribution is in the area of the operation of due diligence. I hope that the Commission's work will be able to provide guidance or a blueprint for how a state should go about complying with its due diligence obligations. One significant contribution would be to set out what a state should do in order to avoid being found responsible for a lack of due diligence. In other words, the Commission could help to clarify how compliance with an obligation is to be assessed through the standard of due diligence. Another possible useful contribution would be to provide clarity on the implications for states exercising control over activities within their jurisdictional control that have harmful effects beyond their borders, and in particular, the obligations of states to regulate private actors. And this includes, for example, transnational corporations that fail to ensure that their activities in other countries do not cause harm, environmental harm, or human rights violations. So what is next? So I'm preparing my second report in light of the convergence of Commission views around due diligence as a standard of conduct. I propose to draft principles on that conception in my second report for consideration by states and by the Commission. I will also seek to identify the various elements or factors that need to be taken into account in an assessment as to whether a state has complied with its due diligence obligation. So this will enable tangible progress within the quinquennium, while leaving some time for further research on due diligence as a possible general or autonomous obligation. So that brings me to a close on how I see the Commission's work on due diligence progressing. As I said, we're at the beginning of a long journey, and I'm taking it very much step by step. There are many issues which will need to be addressed as we progress with this topic. And I hope that this webinar will help to gain further views on and debate on this very important topic. Thank you very much for your attention, and I look forward very much to the comments from Professor Alino.
Thank you very much, Dr. Riding, for this very enthusiastic and fascinating presentation, and also very thought-provoking about the opening questions that are waiting for the Commission, and also some hope that there will be some consensus among states and the ILC members on these common questions. But let's now give the floor to a good friend of Minas Gerais and many members of Minas Gerais Group of International Lawyers, Professor Alice Olino. Alice, please, you have the floor.
Well, first of all, thank you very much, Professor Lima. Thank you very much, Lucas, for this invitation. For me, it is really much an honor and a privilege to be here discussing due diligence and commenting on the first report in front of the Special Rapporteur. This is definitely something that I could not even imagine when I started my PhD on due diligence. So again, thank you very much for inviting me, and thank you very much as well, Dr. Ridings, for being here and for providing me with this very excellent opportunity to discuss like a topic that is very close to my heart, which is due diligence. Now, I will structure my interventions, let's say, around basically four main issues that have been raised by Dr. Ridings, and I hope this way that I will engage with many of the critical points and findings that were illustrated so far. So like a first comment will, of course, like some of my comments, many of my comments derives from my readings of the first report on due diligence. So I will mix some, comments, the fresh comments that I made right now with some more, comments that I made while I was reading the report. So my first comment concerned basically the scope of the topic. So the two conceptions of due diligence that Dr. Ridings has illustrated. The second comments will instead focus basically on the legal content, or the content of due diligence, so the core content on due diligence. The third comment I will make relates to the relationship between due diligence and state responsibility, and then I will conclude with some observations or maybe like a critical remarks about like the contributions of the ILC to the work on due diligence. Now, starting from the first problem, so the scope of the topic, so the two conceptions of due diligence, I think this is one, if not the most critical question and the most critical point of the entire work on due diligence in international law by the ILC. And I very much agree with the Special Rapporteur that there are indeed two conceptions of due diligence that have developed in international law. One is very much attached to due diligence as a standard of conduct, so something that attaches to the primary rules and the interpretations of primary rules, whether customary or treaty-based. And another that relates instead to basically the general obligations that comes from the Corfu Channel dictum. Now, I will not dwell on this since this was very well illustrated by Dr. Ridings. I will say that from my perspective and in my views, I have like these two conceptions concern two distinct analytical questions, and I think that the first report makes this very clear. My concern is actually more methodological, let's say, in the sense that I think that if the Commission, so I can see why the Special Rapporteur wishes to, continue in analyzing both of them, at least for now. I have a methodological concern in the sense that if the Commission proceeds with, engaging with due diligence with the perspective of due diligence as a standard of conduct, this implies certain methodological choices, meaning that it implies, for instance, comparative analysis into like different areas of international law. So looking at, the different criteria that may inform the meanings of due diligence, the content of primary obligations that are interpreted through due diligence. It also means looking mostly at the practice of international courts and tribunals, because this is where actually the concept of due diligence is mostly invoked. So the concept of due diligence is hardly invoked by states unless they, pleads before international courts and tribunals, but is mostly raised by international courts and tribunals in interpreting international obligations. So it means looking at the work of international courts and tribunals. It also means engaging with rules of interpretation. And I think this was made very clear by the advisory opinion of the ICJ on climate change. So like this heightened or stringent due diligence standards that the ICJ, but also the ITLOS, was able to establish basically by interpreting due diligence through other rules of international law. So of course, like underline, there is recourse to rules of interpretation, mostly Article 31, 3C of the Vienna Conventions of the Law of Treaty. So looking at maybe like applied in a way that is not as methodologically rigorous as in other areas, but this would be, what has been done by the ICJ and the ICLOS. So it would mean, engaging with rules of interpretations, the roles, the practice, the functions of international courts and tribunals, a comparative analysis, etc. Instead, I think that if the question is to look at the general obligations of states not to knowingly allowed their territory to be used for acts contrary to the rights of other states, then methodologically this would entail like another approach by the Commission. This to me is very much an exercise in identifications or codifications of the primary rule of international law. So it would be basically looking at the scope of, these general obligations. Is it a customary rule? Is it a general principle? Then it would mean, well, if there is a customary rule, which there is in environmental law, as far as the ICJ or most international courts and tribunals, but also state recognized, does this rule applies also in other contexts, such as the cyberspace, such as, transboundary harm that may entail, different activities which differs from environmental transboundary harm. So to me, this is a question of scope of applications of a primary rule. And so again, like methodologically, it requires a different sort of examinations rather than looking, at the rules of interpretations and comparative analysis, etc. So what I want to say, like what I wish is to say is that in my view, I mean, there is merit in, looking at both conceptions, because indeed this is one of the reasons why due diligence is considered such a vague and, difficult to define terms. At the same time, I think the Commission must be very careful in how it decides to frame the two topics, because methodologically they entail, different approaches. And this is also a bearing and definitely affects one of the second issues that was raised by Dr. Ridings, so the function of due diligence. And the legal status of due diligence. Because again, if we engage with due diligence as a standard of conduct, then of course we may, debate and consider whether due diligence is a principle of international law, like if we refer to for instance, the draft conclusions of general principle of international law, assuming that principle may also inform the interpretations, assist the interpretations of primary rule, we may discuss whether due diligence also perform these functions, right? Or is simply like a standard of conduct, a regulatory standard that is invoked by courts and tribunals or by states in adjudication. Instead, if we look at the second conceptions of due diligence, then I think the questions about the customary status of the obligations, whether it's a customary rule, whether it's a general principle, but as a source of international duties of states' rights and duty arises. And so I think this must be kept like distinguished one another. There's also the risk that, and if they're not, kept as, distinguished to one another, the risk is also that we might see like elements of the first due diligence migrating into the second and the other way around, which may also, complicate or blur even more, the distinctions between the two. So I think that I agree with the special rapporteur that this is indeed one of the crucial point of the entire topic, and will have to be dealt very carefully by the commissions and by states themselves when they discuss this within the sixth committee. Now the second, well, actually I maybe like a minor comments on this also that relates to this. This is something that Dr. Ridings hasn't picked up right now, but it is mentioned in the first report, which is the exclusions of due diligence as applying to business operator to the topic and the analysis by the Commission. Again, I actually agree with the Commission choice to leave out the topic. But I think that, again, if the Commission decides to embark on an analysis that takes into account both conceptions of due diligence, so the general rules and the standard of conduct, then again, the boundaries of the topic requires principle justifications, because to me, these are two different legal questions. So my third questions and the following question would be, well, if we engage with an analysis of due diligence that have different meanings, why these two different meanings and not also due diligence by business operator? So, of course, this is due diligence that applies to business operator, not to states, but there is a commonality of understanding between like all three of them: due diligence as a general obligations, due diligence as a standard of conduct, and due diligence as applying to private actors. So like a methodological remarks in that sense. And now I will move to my second comment and remark that concern the content of due diligence. So basically, here I'm talking about the parameters, let's say, or the criteria, as Dr. Ridings have explained, that inform the content, the meaning of due diligence. So the extent to which knowledge comes into the picture, control of the state over activities, territories, principle of common but differentiated capabilities, and so forth and so on. I think that, again, this is probably one of the areas in which the Commission may made the most contributing, work in relations to due diligence, assuming that we are talking here about due diligence as a standard of conduct. So like looking at the criteria that informs due diligence. Like a remark that I have in this regard is that I agree with the special rapporteur, and I agree with, the findings of the report, that this entails, like looking at the criteria that informs due diligence entails looking at different areas of international law, different primary rules, so the extent to which due diligence and criteria applies into international human rights context, environmental law, cyber law, etc., etc. To me, it's not just questions of fields in which due diligence applies that is worth exploring. It's also a questions of typology of obligations. And I will make myself clearer by saying that I think one of the topics that the commissions should address and is not mentioned in the first reports is the relationship between due diligence and erga omnes obligations, for instance. So all this, criteria that informs due diligence, so knowledge, control, capacity of the state, etc., they are relevant and they change not just in relations to the content of the primary rules or the field in which the rules applied, whether it is human rights or investment or the law of armed forces or whatever, they also change with respect of the typology of the obligations, whether the obligations is, a simple primary obligations or whether it is erga omnes. So this is something that, has been I think it emerges quite clearly in the findings of the ICJ, the ITLOS, but also the Inter-American Courts of Human Rights in relations to the respective advisory opinion on climate change, when they refer to a Huygens standard of due diligence. But also it's relevant in other contexts. It's relevant in the advisory opinion of the Seabed Chamber of 2011, in which it seems that the concept of common but differentiated responsibility might not play this role, like strong role, as it would play in other contexts. It is also relevant in the context, for instance, of genocide. So the idea that the spatial scope of applications of due diligence may be enlarged if the obligations of erga omnes, so extraterritorial due diligence, if we want to call it as such. So the idea that all states are bound by the obligations to act with due diligence to prevent genocide. So the fact that the obligations might be characterized as erga omnes or may, underline a concern of the international communities, or may be attached to a preventive duty in the common interest, may affect the variables that attaches to due diligence. One would also be, for example, the questions of knowledge. So I agree with the special rapporteur that this is, again, a crucial aspect to be clarified in relations to the criteria that inform due diligence. So a question is, for instance, whether constructive knowledge may, in the case of obligations erga omnes, or at least certain obligations erga omnes, but constructive knowledge, instead of being inferred simply by the material available and the informations available to the state, may require instead the state taking active steps to, acquire knowledge. So making prior and preliminary assessment to determine whether a risk exists in the first place and then taking place. This, of course, is an approach to knowledge, which is different to, requiring the state to act vis-a-vis risk that are known or knowledgeable, depending on the informations that the state has. So again, I think that the typology or the quality of the primary rules may also inform, the standard that is applicable. And following questions that ensure from this is also the relationship of due diligence with other standards. Because I agree with the special rapporteurs that there is the need to, confront due diligence with other principles, such as cooperations, for instance, of prevention. But I think engaging with the criteria that informs due diligence also implies engaging with the concept of precaution, for example, to what extent precautions relates to due diligence and integrate into due diligence. The concept of due regard, which is also closely linked to due diligence in certain contexts. Moving to my third point, and third and fourth will be briefer, let's say. So the third point is the relationship between due diligence and state responsibility. I think this is a classic questions of due diligence. So which place does due diligence occupy in relations to state responsibility? Where does it sit? It's a question that was also addressed by the International Law Commissions actually during the work on state responsibility. So Draft Article 11, adopted by the commissions on the first reading, actually addressed, let's say, this problem or the link between attributions of conduct, let's say, and state responsibility by omission, basically by saying that even if the conduct of private person is not attributable to the state as per rules of now Article 8, basically, still this does not preclude the state responsibility based on other rules of attributions. This was basically the rule conceived by AGO. There was not explicit reference to due diligence at that time, but AGO really much had in mind state responsibility for omission, so for failing to prevent harmful event. So this is a classic theme, as I said. I have to say that from a personal perspective, I have quite a, not radical, but my view is just simply that due diligence sits within the realm of primary rule. I don't see like due diligence in something that sits between primary and secondary rule. I mean, if we wish to, keep the integrity of the ILC work on RCWA, I think the only logical conclusions is to say that due diligence sits within the realm of primary rule. Nonetheless, I do think that there would be much merit into the Commission looking at the relationship between due diligence and state responsibility. And in particular, I think that if the Commission's does so, there are basically two main questions or issue that would be relevant that needs to be addressed. So the first is the questions of causation. So once we want to engage with due diligence and state responsibility, I think the questions arises as to whether causation is relevant in determining state responsibility for failing to prevent. What is the causal link between the event that should have been prevented and the conduct of state? This is also a question that has been explored recently by the doctrine, and it is a question that still is, worth of analysis by the commissions. It was left out by the work on RCWA. And the second point, which is very much related to this, I think that if due diligence is analyzed in relation to state responsibility, this also entails an analysis or, let's say, an engagement with Article 14, paragraph 3 of RCWA. So the breaches of obligations to prevent, according to Article 14, paragraph 3 of RCWA, and obligations to prevent is breach once the event to be prevented has occurred, basically. So unless the event occur, there is no responsibility for a state for failing to prevent the event. And I think that this is an area that is worth exploring by the Commission in the sense that the ICJ, for instance, took this approach in the genocide case and established that of course, responsibility for failing to prevent genocide can only be established once genocide has occurred, but then stated that an obligations to prevent genocide arises the moment the state learns of genocide. So there was a bit of a paradox, let's say, or a logical leap in the way in which the commissions interpret and applies Article 14, paragraph 3 and the concept of due diligence, provided that we understand due diligence as applying to obligations of conduct, basically. And I think it's a relevant question because it is a question that has been raised, or it is an issue that is emerging, for instance, also in international, but especially in domestic case law concerning third state responsibility for failing to prevent genocide in relations to the conflict in Gaza. So whether, this domestic court are equipped or can actually judge about third state responsibility to failing to prevent genocide if genocide in Gaza as or as not occurred already, or if the responsibility of Israel has been established in that regard. So this is a question that needs engagement, and in fact, the very framing of Article 14, Paragraph 3 of RCWA by the ILC in 2001 was indeed the result of debates within the commissions on the conceptions between obligations of conduct and result, and the understanding of obligations of preventions and their relations to due diligence. And finally, and with this, I will conclude my intervention. So I have a comment basically on the contributions of the commissions to the work on due diligence. So I very much agree with Dr. Rydin, and I think that the ILC can very much contribute to a better understanding of due diligence, and I see much potential into contributing to the criteria that informs due diligence, to identifying, as Dr. Rydin was saying, parameters that would guide state into operationalizing due diligence in the context of primary obligations. One, comment or concern or just, a thought that I had while I was reading the first report concern actually this work of clarifications and maybe, I don't know, like a warning about excessive rigidity into like the contributions that the commissions may do in clarifying due diligence. So what I mean is that the clarifications, the exercise of clarifications that the ILC may do shall not crystallize maybe due diligence in a closed formula that would disable, let's say, the very flexible character of due diligence, which I think is one of the strengths of the principle or of the concept. So, like reading the first report, there were debates within the commissions about whether, and this is something that was raised by Dr. Rydin as well, about whether the commissions should engage in an exercise of taxonomy, so identifying, for instance, the trigger words that would enable a better understanding of where due diligence applies, or whether due diligence applies to obligations of conduct or obligations of result. I think this is great work, but I would be cautious about like the rigidity of engaging in an exercise of taxonomy of international obligations in that sense. Well, I was the first to engage in an exercise of taxonomy in my book, Taxonomy of International Obligations. But from the perspective, so I see like the appeal in doing so. But at the same time, I also think that this was a concern within the ILC during the work on state responsibility, whether excessive codifications, for instance, regarding obligations of conduct and obligations of result, would have resulted into a too rigid, categorizations of international obligations. And I think that this might be a concern also this time in relations to due diligence and its relations to obligations of conduct, obligations of result, to which obligations it would apply. And my final remark that regards due diligence in general is that I think that the flexibility and the flexible character to which due diligence is normally attached is not the same as vagueness, in the sense that vagueness relates to the indeterminacy, or let's say, of due diligence as a legal standards, whether due diligence has a normative value. I think that it does, and the work of the ICJ, the ITLOS, International Courts and Tribunals has widely demonstrated that, but it's something different from flexibility that is one of the greatest strengths of due diligence in this sense. So the capability of evolving over time, applying to different contexts and different obligations. And with that, I think that I can conclude my comments and discussion. And I hope that was clear enough. And I'm looking forward for the questions. Thank you.
Thank you very much, Alice, for this very, very thought-provoking commentary. When I finished reading the first report and after hearing Dr. Rydin's, I believe that the topic was already very complex, but after hearing you, I'm quite convinced that this topic is huge defy to the Commission in many, many aspects. Thank you very much for this very thoughtful reaction. So, Dr. Ridings, I imagine that it will not be possible to touch on all Alicia's points, but the floor is yours to a reaction to this very interesting reaction.
So I want to thank very much Professor Alino. You have encapsulated in a short space of time some of the real challenges that I have as Special Rapporteur and that the Commission has. Just perhaps rather than, I mean, I will look at some of the points, but just to try to explain a little bit more about my role. It's a challenging role because one way to look at it is that I need to discuss all these concepts with not only the members of the Commission who have, in many cases, different views, but also with states. And so my role is to try to bring a common understanding together. And so that is a very, very challenging role that I have. With respect to some of your specific comments, yes, the two conceptions, they are different methodological choices that need to be taken. One of the big problems with the due diligence as a standard of conduct is there is very little state practice as state practice in this area, as you rightly pointed out. I have in the annual report, I have put out requests to states for examples of state practice. And this will be very important. In addition to the main state practice is in terms of pleadings before courts and tribunals. But also there may be national decisions which may not refer directly to due diligence, which in many cases they don't, but there may be some national courts of decisions that may be relevant to due diligence as a standard of conduct. Yes, as a conception, the second conception, it's very much a codification progressive development aspect. So it is a different methodological choice. One of the concepts out there is to whether there can be a unitary concept of due diligence crossing both conceptions. I'm going to look at that, but my process, I'm taking a very deliberate process by looking at standard of conduct first and then extending that out. That was mostly done in order to not bite off the hardest part of the apple before dealing with something which is a little bit easier. It also will help because our terms are 5-year terms, and so there will be a new quinquennium starting in 2028. So this means that different commission members may have different views. So it enables them to address their points as well. The point you made about business operators, it is I'm still deliberating on that. The key reason why I didn't include the scope ratione personae, if I can use that term, to include the obligations of business operators and transnational corporations is mostly because of the size of the topic and the needing to make sure that I didn't have a topic that was too large. Of course, the actions of transnational corporations are relevant, and it's not that I'm excluding any of those aspects. They are definitely relevant, but I'm not looking directly at, for example, the UN Guiding Principles on Business and Human Rights. In terms of the content of the parameters, I think that the point you made about engaging not only with the various parameters, but also with some aspects of that, like knowledge and the criteria to inform constructive knowledge is really very important. Also engaging with some principles such as precaution and due regard. So that will be very important in examining the issue of the content. The typology of obligations, particular erga omnes obligations. So there is a new topic that's going to be started on obligations erga omnes, which is very relevant. And so I'm glad not only that we're undertaking that topic, but also that you raised that very important point, because I think you're absolutely correct that depending on the obligation, the standard will differ. In terms of the issues regarding state responsibility, this will require quite a lot of work for exactly the reasons to make sure that there are issues addressed, such as the causation, but also the breaches of obligations to prevent in Article 14.3. It's very interesting to look back, as you have looked back at the history of the articles on state responsibility and see the different views and how we ended up where we are with the articles. And my basic precept is not to interfere with the draft articles on state responsibility. And I have no desire to interfere with those. There are, as you know, quite a few different perspectives on whether due diligence sits sort of between primary rules and the secondary rules of state responsibility. So I think I will be very cautious in the way that I approach the state responsibility. And then finally, your point about the need to not have excessive rigidity in whatever the conclusions are. I totally agree with that as well. And it requires caution again. So the prudence and caution is something that I have been advised to be very cautious and careful in my approach. And so I will, and it's a very useful thing to always remind myself not to get too carried away, can I say, with making sure that everything is clear, but leaving out the flexibility which enables a concept such as due diligence to have important meaning. So I want to thank you for all your comments. I thought they were extremely useful. And I certainly agree with all of them, and also with the general view that I need to be careful in how I approach this topic. And so it's no small task, unfortunately.
Thank you very much, Dr. Ridings. Now we move to the second part. I hope that we still have some time to that. But I would like to thank once again, on behalf of the ILA Brazilian branch, Dr. Ridings, Alice Olino, Professor Olino, for this really useful discussion. I hope that you that are watching now on YouTube enjoyed this discussion as much as I enjoyed, and I'm looking to the face of the participants here, certainly also enjoyed. And I will stop the recording now, and then perhaps we can continue the discussion with Dr. Ridings and Professor Olino. So